So if you're not consenting to this court's jurisdiction, sit down.
Oh,
You can.
I'm Chuck Graves, and what you're about to watch is a woman walk into a courtroom, look a sitting judge dead in the eye, and try to use the internet's favorite legal cheat code to keep $1 million house she has no right to be in. Spoiler, it does not go well. In fact, it goes so badly, the judge ends up charging her $15,000 a month for the privilege of losing. Let's break it down.
Ms. Banks claims to be an occupant of the property. She filed a bankruptcy case listing the property as hers. The bankruptcy stay was lifted, which gave rise to our motion to reopen the case.
So here's the setup. This is a civil eviction hearing over a property worth somewhere around $1 million. There's unpaid rent, there's a stack of bankruptcy filings, and there's this woman, who, and I want you to hold on to this, is not even a named defendant in the case. She doesn't have to be here. She inserted herself, and she came loaded with a plan.
and oppose an unlawful state action. I expressly do not consent to this court's jurisdiction and do not.
Well, then
Any right.
you are not a named party. So if you're not consenting to this court's jurisdiction, sit down.
Oh,
You can.
And there it is. I do not consent to the court's authority. Beautiful. This is the cornerstone of the whole sovereign citizen religion, the belief that a court is like a vampire, that it can't do anything to you unless you invite it in. Here's the reality. Jurisdiction comes from the law, not from your feelings about the law. A judge does not need your consent any more than a red light needs your consent. You can stand in the courtroom screaming, "I don't consent," all day. The case proceeds without you, around you, and eventually on top of you.
that I stated that I'm not. Oh, I lost my spot. Not consenting to this court's jurisdiction. So I'm going to recant that
So you are consenting to this court's jurisdiction.
at this moment. Oh,
Well, no.
Now watch this. She's reading. She brought a prepared statement. Somewhere there is a YouTube video or a $40 PDF that told her these exact magic words would work, and she practiced them. And I almost feel for her, because the people selling this stuff are genuinely convincing, right up until the moment a real judge is sitting 10 feet away, completely unimpressed.
Since then, there have been multiple bankruptcies. Ms. Whitlow filed 2 different bankruptcy cases. A young man who apparently lives in Arizona filed a bankruptcy case and listed this property as his residence. Ms. Banks has filed a bankruptcy case and listed the property as her residence. It should also be noted that Ms. Banks was a bankruptcy preparer and has been forbidden from the bankruptcy court from preparing bankruptcies for anyone other than herself.
Okay, here's where it gets sophisticated and genuinely a little dark. The attorney is laying out a pattern of repeated bankruptcy filings. This is the move. When you file for bankruptcy, an automatic stay kicks in that temporarily freezes proceedings against you, including evictions. So the play is, file a bankruptcy, freeze the eviction, let it get dismissed, file another one, freeze it again. It's not a legal argument, it's a stall, weaponized. And courts have seen it 1,000 times, which is exactly why this one is about to come down hard.
I do have time, I do believe, to go file an answer and counterclaim. I was just led under
An
false
answer and counterclaim to what?
to their complaint for eviction.
You have a lease with, allegedly, with Miss Whitlow.
Correct.
Then that is who you need to pursue it against,
Okay. And
or whatever the heck you're doing. Because you don't have, there is no privity of contract to the extent there would be, or relationship as between the plaintiff in this case and you.
okay, I'm not really understanding, but
Well, let me put it a little bit more simply. If I
And here's the judge doing the thing I love: calm, patient, surgical. You can't file answers, objections, or counterclaims if you're not actually a party to the case. That one sentence vaporizes her entire strategy. Everything she filed, every objection, every I don't consent, legally weightless because she's not a party. She built an elaborate fortress on a piece of land she didn't own. Watch it come down.
I can have the issue with the plaintiff in this case because they have right to own the property.
Okay. All right, Your Honor, I will speak with the Whitlows that I have finally got an understanding of everything. And
She's still going. They always keep going. Because in her mind, she hasn't said the right magic word yet. If she can just find the correct phrase, the correct citation, the judge will be forced to release her. That phrase does not exist. It has never existed. But the belief that it's out there is the entire engine of this thing.
In this case, I'm going to issue a judgment in the plaintiff's favor for possession with a writ to issue 10 days of my signing. Should the matter be appealed, also contained in that judgment order, the appeal bond I would set at this time at a rental rate or a rate, and I have looked at the property which is involved in this matter, and it is a significant property. I don't think the $10,000 a month quite does it based upon my calculations. So any appeal bond would be set in the amount of $15,000 per month that would need to be paid to maintain the appeal.
And now the hammer. $15,000 a month. That's the bond the judge sets to keep occupying the property during the appeal. Think about what just happened. She walked in trying to live somewhere for free, and she walked out owing $15,000 a month for the right to keep fighting a fight she's already lost. The no jurisdiction defense didn't make the cost go away. It made it worse.
Prepare that and present it to you this morning.
may I say something? Our lease payments was not that high at all. I'm not sure what her mortgage payments were. That was not our amount we paid.
Then I'll tell you what. If the Whitlows wish to come and object to my order of $15,000 as an appropriate bond, they may do so. I do not believe that you have standing to object to the court's order.
She didn't pay it. Of course she didn't. Within days, a writ of eviction. Then the formal order. The whole sovereign citizen playbook. The no consent, the no jurisdiction, the bankruptcy-stall. Bought her a few extra days and a 5-figure monthly bill. And then she was removed from the property anyway. So here's the lesson under the chaos. And it's the same one every single time. The law is not a video game with cheat codes. There is no magic sentence, no PDF, no I do not consent that makes a court disappear. The people who sell you that fantasy are not in the courtroom when it falls apart. You are. Knowing your real rights protects you. Knowing fake ones gets you a $15,000 a month bond and a viral video. I'm Chuck Graves. If you enjoyed watching this one fall apart in real time, subscribe, because there is a truly endless supply of people who think they've found the cheat code, and I will be here to watch every single one of them find out they haven't. See you in the next one.